In the previous video, we have discussed Article 171 of the Constitution, which was related to the constitution of legislative councils in states. In the present video, let us discuss Article 172, 173 and 174. Article 172 and 174 relate to duration of legislatures of a state, whereas Article 173 is related to qualification of members of legislatures. Article 173 says that the qualifications required of members of legislatures are as follows. Number 1, they shall be citizens of India. Number 2, members of legislative assemblies shall have at least 25 years of age, and members of the councils shall have at least 30 years of age. We know the age limit for president and governors are 35. So the age limits for MLAs and Lok Sabha members and members of legislative councils of the states and council of states of the union, they are 25 and 30 years respectively, while it is 35 for president and the governors. Please think for a while, when we are treating president and governors as secretaries to the legislative leaders, what is the necessity of their being older to members of the assemblies and the councils? It is a misnomer. We are treating president and governors as secretaries. If given an opportunity, what kind of secretary would you appoint? You will appoint a beautiful secretary who is younger to you. Why you select an old man or woman to be your secretary? It is a funny thing. In fact, they are the masters of Council of Ministers. Council of Ministers are appointed and removed at the pleasure of the President and the governors. Let it be apart. Let us discuss Article 172 and 174. Article 172 says that the duration of an assembly shall be 5 years unless sooner dissolved. However, in case of progress of an emergency, that means when an emergency is in progress, under Article 352, the elections to a state assembly or the parliament may be extended by 1 year each time. However, they shall not be extended beyond 6 months after the end of the emergency. And the end of 5 years term shall operate as dissolution of assemblies. This is what contained in Article 172. On plain reading of it, there is nothing to be disputed. Coming to Article 174, it says that the governor shall from time to time, please remember this word, from time to time, shall prorogue the assembly, shall dissolve the assembly. We know the legislative councils cannot be dissolved any time. Only 1/3 of its members retire by rotation every 2 years. Only assemblies get dissolved on completion of term of 5 years as per Article 172. Apart from that, under Article 174, assemblies are dissolved from time to time, prorogued or dissolved. This is what Indian administration has misunderstood. The word dissolve was misunderstood to mean dismiss. Even under Article 356, if the President of India is of the opinion that the administration of the state cannot be run in accordance with the provisions of the Constitution, based on the report of the governor or otherwise, will dissolve the assembly and will dissolve the state government. The responsibility of the state legislature, namely the assembly, is taken over by the parliament, and the functions of the governor or the government are taken over by the president or his assigns. There is a clear distinction between legislatures and the executive, which Indian leaders have failed to understand. Action under 356 is only a temporary affair. Dismissal means suspension, because suspension or dissolution under Article 356 cannot continue for more than 3 years. We know Congress party lost to Janata coalition in 1977, mainly on the ground that Mrs. Indira Gandhi has imposed emergency and oppressed the opposition parties and took away the fundamental rights of citizens. The Janata coalition party also, without knowing what the constitution is, what democracy is, what republic is, what are the functions of the governor and the president are, simply passed 44th constitutional amendment in 1978 and said that the declaration under Article 356 cannot continue for more than 1 year. We have no objection. Declaration under Article 356 is not continued for beyond 1 year. Nobody should have any objection. In case things are not settled down, the President may extend it further. So when we said that the dissolution is time bound, maybe 1 year or 3 years, we must understand that it is suspension but not dismissal. If it is a dismissal, the question of time limit does not arise. But unfortunately, assemblies are being dismissed on the request of the Chief Minister on the resolution passed by the Council of Ministers. The Governor is reporting to the President of India, and the President is happily making a declaration under Article 356. So states are going for midterm elections. This is a heinous crime against democracy and the Constitution. People have elected their representatives to represent their problems in the legislatures for 5 years. Why their membership should be dismissed? They have not contacted any disqualifications. And who, after all, anybody else is to dismiss their memberships, supposing it is the Council of Ministers who are doing it. Sometimes the Council of Ministers, including the Chief Minister, may not be members of the Assembly at all. They could be nominated members of the Legislative Council, and they being not members of the Assembly, how can they declare that the Assembly should be dismissed? I am surprised the so-called leaders, none of them stands up and raises his voice to question who is cancelling our memberships and why. We have not done any wrong thing. Neither the people have done any wrong thing in electing us. Who is dismissing our memberships and why? Whether they have such authority, if so, under which article of the Constitution? Instead, they are happily running home like school children after the home bell is rung. Because elections are like festivals in India, the bigger leaders try their luck once more, whether they could become Prime Minister, Chief Minister, other ministers, etc. And the smaller leaders would try their luck once again, whether they would be part of a ruling party. They can collect funds from people as much as they can, and the cadres and voters also, it is a festival like thing. They get remuneration for working for the party, and voters get remuneration for participating in the election process. This is most unfortunate thing. It's a spoil sport. You please understand the language of Article 356. It is only when the President of India feels that administration of the state cannot be run in accordance with the provisions of the Constitution, but not as and when the Chief Minister advises. It is the President who should feel that administration cannot be run in accordance with the Constitution. Internal disturbances, violence, or anything should not be treated as which result in administration of the state not in accordance with the Constitution. To deal with law and order situation, there is already Article 355. The state can send army and suppress the internal disturbances. By changing the assembly, the same government administration, how a law and order situation will be improved. The same persons may become chief minister and ministers, and the same government officers, police officers would continue to be there. And how after elections you can deal with law and order situation. Article 356 is not meant to deal with law and order situations. Unfortunately, we are dismissing elected governments and going for midterm elections, whereby there would be elections throughout the year in one state or the other. This is a system enunciated in Pakistan Constitution under Article 58 and 112. In Pakistan, if a chief minister advises the governor to dismiss the assembly, the governor has to do it within 48 hours. If the governor does not do it within 48 hours, the assembly is automatically deemed dismissed. Would there be any more draconian provision than this? Then they have to go for midterm elections within 90 days. We do not find any such provisions under Indian Constitution. To my surprise, India is following the provisions of Pakistan Constitution. You can ask any constitutional expert to show under which provision the legislatures are dismissed. Leave about assemblies. Even Lok Sabha is being dismissed by our so-called great leaders. It was done 5 times in the past, starting from 1971 by Srimati Indira Gandhi. If a legislature is dismissed, state legislature, its responsibilities are taken over by the parliament. Supposing if the parliament is dismissed, who else will take the responsibilities of the parliament? As such, there is provision for dissolution of assemblies, rather their suspension. But such provisions are not there as regards the Lok Sabha is concerned. Even during emergency, parliament continues to be active. Only certain fundamental rights are kept in abeyance, but the parliament is not dismissed even during declaration under Article 352. Thank you. Thank you for watching my videos. I am Haribabu, an advocate at High Court for the state of Telangana. I have started this web series to bring to the notice of the listeners the controversial, contradictory provisions of the Constitution which were misused, misunderstood, misapplied, as a result of which we are suffering political instability, political uncertainty, political immorality, and the resultant social strife and poverty, external terrorism, and internal extremism. It is time for the citizens of India to read and understand the Constitution and understand the basic tenets of democracy. I request you to please subscribe, share, and comment on my videos. I will be glad to reply to your worthy comments. Thank you.